Please be seated. This is the time set for oral argument in the matter of Goodyear against Warner. Our cause number 1CA SA150305. Counsel, I'm sure you're aware we have read the papers you filed. We're familiar with the record, and you can bear that in mind as you begin your presentations. Because you're being audio and video recorded today, if you'd announce your identity and that of the party you're representing, that would help us out. Each side will have 20 minutes for oral argument. The petitioner is free to reserve as much time as you like, subject to your own control of your clock. And with that, we can begin.
Thank you and good morning. I'm Foster Robertson with the Lewis Roca Law Firm. At counsel table with me, Walter Yoka of Yoka and Smith, co-counsel pro hac vici. I would like to try to reserve 5 minutes of my time. The issue that is presented in the petition is the risk of discoverability of valuable trade secrets that will occur if the plant inspection that was allowed by the trial court takes place. The plaintiffs have acknowledged that my clients have no adequate remedy on appeal, and that in fact is the case. If this manufacturing plant inspection takes place, valuable trade secrets, all the evidence before the court puts that value at millions of dollars, will be put at risk.
How is that? The plaintiffs have agreed to take the same tour that's been offered to other outsiders. Exactly what is going to be revealed that is a trade secret causes you concern?
Your Honor, if you look at the declaration of Tim Noe, N-O-E, who was the plant manager of the appendix, that provides the overview of what's at this manufacturing plant and what.
Sure, but it doesn't really answer the question directly. It basically makes the case that there are trade secrets within the manufacturing process. And I'm sure that there are trade secrets that go into the development of and engineering of what happens at the plant. It doesn't really make the case for how giving the same tour offered to others is going to reveal those trade secrets.
Well, let me say that I believe it's error, and it is to think, and it's outside of the record to say that it's the same tour offered to other people. Let me come back to that in a moment.
I'd like to as well.
And finish addressing the no issue, the Mr. No's declaration. If you look particularly at paragraph 12 of his declaration, he says that the trade secrets are immediately accessible upon an open inspection of this facility, and he says that they would be particularly decipherable to experts in the field. What the plaintiffs propose to, and then the declaration also goes into talking about how there's customized equipment, customized machinery, customized processes in this plant. So the only record before the court and what's been established is that this place is filled with trade secrets. What the plaintiffs propose to do is go through that plant not only with counsel, but also with their expert witness, a fellow named Dennis Carlson, and his unidentified assistant. The risk to the trade secrets, which are there, and the record shows are accessible and discoverable upon viewing, is at multiple levels, Judge Swan. But one of them is through Mr. Carlson. Mr. Carlson is part of a very small group, about a half dozen plaintiffs' lawyers who regularly on an ongoing basis testify in cases involving other tire manufacturers. So in other words, Mr. Carlson is in direct, regular communication with competitors of Goodyear.
Is this about the secrets, or is it about Mr. Carlson?
It's about the secrets and the fact that he is one potential conduit of the secrets to competitors. He writes reports. analytical reports, those go to competitors. He testifies in depositions and trials. Those go to the competitors in the expert process.
Does the protective order stop Mr. Carlson from revealing confidential information that he learns from this plant? Is it if he was in other cases?
If there are protective orders in the other cases, then Judge Kessler, there usually are protective orders in the other cases. There's a
protective order in this case. There's a protective order in this case.
The protective order in this case has not been applied and does not really lend itself to application to the inspection.
I understood that. And I saw that when I viewed the protective order. But my question is, assuming that a protective order could be applied, as I understood the protective order, if an expert sees trade secrets, he can only use it in this case. And his notes are protected. In other words, he or she can't then go willy-nilly and say, I'm going to use them in other cases, I'm going to reveal them to competitors. He is governed by and has to sign off on that he understands the protective order, right?
A protective order could be fashioned that would have the impact that you're suggesting, Judge. The issues then are these. First of all, and Judge Swan asked, is it about the expert? Mr. Carlson has a record of disregarding protective orders.
But we can't sanction plaintiffs by denying them discovery for the prospective violations of their expert, right? I mean, we can't assume that our orders have no effect.
And there's no question here, no request to sanction them. What the request by my clients is that the trial court, and now this court, because the trial court did not do so, apply the proper standard for discovery of trade secrets, and that standard is reasonable and necessary, and that was not done.
It's effectively a sanction, though. If we are to say that this expert is so out of control that we, the courts, are toothless to enter enforceable orders against this guy, and therefore, plaintiffs, you can't have discovery that you could have had if you had a better expert, that's effectively a sanction.
I would disagree with that, Judge Swan, because if the expert is Joe Blow rather than Dennis Carlson, the legal standard is still relevant and necessary. These plaintiffs themselves, their lawyers, no one can come into this plant and have access and put my client's trade secrets at risk without the showing above the ordinary relevance showing, and there's no evidence, there was no affidavit by Mr. Carlson, no explanation of why going into this plant is necessary.
Well, and I'd like to get to that, but I guess the question before we get there is this special action premature? Judge Warner invited the parties to meet and confer about the parameters of the tour, I believe the court called it, and that doesn't appear to have happened.
Well, part of that has happened. There has been communication on that, but if the inspection goes forward, there will undoubtedly be additional conferences. But the meet and confer process is not going to solve the problem of access to this plant. If there is any meaningful access to this plant through the inspection is synonymous with access to the trade secrets.
You're saying, Mr. Robertson, that there's nothing that can be done from a logistical standpoint to eliminate or reduce the risk of exposure to these alleged trade secrets?
It is not. I am saying that there is nothing that can be done to remove the risk. Certainly, access to a particular laboratory might not be allowed, or a particular machine that was in another line that was not relevant to this case might be screened. But based on Mr. No's declaration and the way these plants operate, there's so much technology, so much in these plants that are unique to Goodyear and that gives Goodyear the competitive advantage that access to the plant and access to the trade secrets is synonymous.
How many people work in the plant?
Over 1,000, Your Honor.
So you've got over 1,000 people, most of them hourly workers, who come and go and who instantly see trade secrets the moment they enter the plant, and yet nobody has spilled these secrets in years.
Well, several things about that. First of all, the employees themselves are restricted, based on the record that you have in front of you, to certain parts of the plant. Just because I may work at that plant, I cannot wander around and go wherever. And I would say to you that parts of of the soup to nuts inspection that the plaintiffs have requested would be parts of the areas that are not accessible to all employees. They sign confidentiality agreements. Those things are monitored, and under the enterprise leasing versus IMKI case and general trade secret law, trade secrets you do not have to maintain absolute secrecy to protect trade secrets. You have to have reasonable secrecy or reasonable measures, and that occurs at this point.
Whether they are trade secrets, and I don't think anybody's disputing that they exist. I think we can accept that trade secrets exist there. The question is whether this notion that one is immediately struck with them upon entering the plant really holds water to the point that we can find an abuse of discretion.
Well, I think what I said, or what I meant to say, Your Honor, is that a meaningful inspection of this plant is synonymous with access to these trade secrets. If they want,
it's going to be for the petitioners to argue, or for the respondents to argue, right? Because I assume that a somewhat less meaningful inspection might be possible.
If they
seem in a mood to make concessions.
If they want to go into the reception area, and look at some nice pictures on the wall of Goodyear symbols.
There are vending machines they can see.
If they want to go into the warehouse at the end of the process and look at some tires stacked up, but what they want to see is they want to start at mixing. And that's where the rubber begins to be made, and they want to end at quality control. That is the entire inspection line. And yes, Your Honor, not only am I saying, but the record says if a person like Mr. Carlson, who is an expert in the field, walks that line, he will see not a trade secret, but multiple trade secrets. And if those secrets are disclosed to competitors through his regular access or even through a nefarious act, and I didn't quite be able to finish answering your initial question, Judge Swan, because it's not just that Mr. Carlson may fail to segregate the information, may not recognize, Judge Kessler, what is or is not under a protective order. It's like the issue of inevitable disclosure in the trade secret context for employees. They know so much information that if they're going to go to a competitor and work, it's inevitable they're going to use some of this. He does comparative work.
But in this case, if you could fashion a protective order, you can label something as confidential or highly confidential. And so everybody knows, oh, look, those are words I understand, highly confidential. That's pretty clear what that means.
Well, I don't exactly know how you do that in this context, whether you take Post-its and you stick it on the assembly line with an arrow, highly confidential, less confidential.
Everything they see is highly confidential.
From start to finish.
Anything they see or learn.
And then it would be under a protective order. So there would be a piece of paper with a judge's signature, and then we are relying on several things.
We tend to value those.
And I'm not denigrating those. I've worked in this field for a long time, and I respect orders, Your Honor. But everyone doesn't respect orders the way that we do, and we have a record here where we've shown you that there is an individual who would be in our plant and have access to millions of dollars of trade secrecy, who has a record of not so much respecting them. We've also shown you a record that these trade secrets are so valuable that there actually have been instances of espionage, industrial espionage, to discover these. That's in the Howley case, where individuals were prosecuted just a couple of years ago for going into another Goodyear plant.
Counsel,
yes.
Could we get back to the question about why is this tour or inspection different than the other tours or inspections that have occurred?
Yes. All right. So, what is in the record about tours? The only thing you have in the record about tours is the information in Mr. No's declaration that visitors have been allowed under limited circumstances. There is no public tour. Then the plaintiffs have also trolled the internet, and they've come up and they presented some information which is anecdotal at best. there is no public tour available. You cannot go up. This is not like the Budweiser plant tour in Milwaukee. You cannot go up and say, I want to sign up for the tour. There have been visitors on a selected basis who have been allowed in some plants, such as a U.S. Senator from Kansas was allowed to go in and see portions of a plant in Kansas and address some of the workers. But the suggestion that those limited visits that are allowed on Goodyear's terms and Goodyear's terms only, that those somehow mirror what these plaintiffs would be allowed to do under Judge Warner's order is simply unfounded. It's not true.
Vague, though. We don't know. It was left intentionally vague because we don't know exactly what would be part of this inspection or tour.
Well, I beg to differ with that, Your Honor. But we went back to the court and we asked for reconsideration. We asked, we said, can we rethink the process of there being a tour? And of course the trial court denied the reconsideration. So what is settled, what will occur without action to vacate the trial court's order is there will be a tour. Now, again, will there be, and trade secrets will be revealed through that to an expert who has the ability to understand them, to use them, and to pass them along to competitors, either intentionally or unintentionally. So all that is available, and a meet and confer is not going to resolve any of that.
Well, is that really true? I mean, if the viewing of each component of the process is limited to a certain period of time, for example, I assume that would help.
Well,
but that hasn't been discussed, even though Judge Warner invited the parties to do that, which is why I ask whether we're here prematurely.
Well, we made the decision to move forward because there was some indication in the trial court that of wanting to do this on a timely, urgent basis. The plaintiffs' counsel communicated with us, wanting to do the tour even before the first of the year. Judge Warner did give an extension or a stay until January 15th. So yes, we made the decision to proceed with the special action. But if the inspection that has been allowed by the trial court remains anything that is in any sense meaningful and will allow the plaintiffs and their expert to learn anything about the manufacturing process, it will be revealing of trade secrets. There is no meet and confer that can do anything short of limiting their access to only trivial, non-meaningful places in the plant that will protect these trade secrets.
Counsel, where is it in Mr. No's affidavit or declaration that talks about how those other tours are different than, or that there haven't been similar tours or inspections?
Well, where he talks about the fact that there are visitors, Your Honor,
could you point to the
it's in paragraph 10. And he talks about the approved visitors must identify themselves to security employees. I'm now looking on page 4. Line 7, employees accompany the visitors, vendors are restricted. That is the evidence you have in front of you.
What doesn't tell us how, I'm sorry, but that, to me at least, doesn't really explain how this tour or inspection is different than any other tour. I mean, I assume that you'll know who's coming in. They'll be accompanied by people from Goodyear employees. That if there's a dispute about what they can see or what they can't see, you could go back and meet and confer and then go to judge. If there's a dispute that this isn't going to be protected, there were risk of losing trade secrets because of this aspect of the tour, you can go back to Judge Warner. And as you pointed out, even if the protective order that's in place doesn't apply to the tour, you can point that out to Judge Warner and say, we need a different protective order.
Well, exactly, Your Honor. This information does not lay out in detail these limited visits that have been allowed. That's the plaintiff's burden. The plaintiffs, under the law, under the Coronet Stores case, as abbreviated as it is, and then the general law of trade secrets from other jurisdictions, once a party in my client's position comes forward and shows there are trade secrets at risk, The burden goes to the party seeking the discovery to show relevance and necessity and the balance of harm. So what they would need to come in and show, and they have not made any kind of showing, is that these tours have revealed things.
To take the risk of paraphrasing Secretary Rumsfeld, they don't know what they don't know. If they haven't had a chance to see what's in the plant, how can they say, well, here's why we need this, here's why we don't need this, and here's how this can be protected?
Well, because they have an expert, Mr. Carlson, who has worked in tire work for over 20 years, and what we've seen in other cases where inspections have been requested is that typically the expert comes forward with some affidavit saying, I need to see the second stage building machine. I need to see this aspect. Usually we see more narrowed orders that go to specific parts of plant operations supported by the expert. There's nothing like that. Or we see some evidence coming forward and saying there was public access allowed to this plant, and therefore this technology is already known. It's already outside of the plant. It's now known, it's now public. Nothing like that. The burden I submit, and I see my time is used up and my 5 minutes have evaporated, but the burden for all of these things will be on the plaintiffs, and they, I would submit, have failed to carry that burden. Thank you very much.
Thank you, Your Honors, and may it please the Court, my name is Kristen Schreiner, and I represent Real Parties in Interest, Officer Jeffrey Darden, Melissa Fowler, and Richie Chin. I'm also accompanied by John Osborne. First of all, let me be clear that there is no absolute bar to trade secrets. When a discovery request is made, there is no law that states simply because a trade secret objection is made that discovery cannot be had. Instead, the trial court is to use reasonable means to balance the interests of the parties to protect the trade secrets while allowing for discovery.
So are you saying that you need access to trade secrets?
We need access to this plant. And
not my question.
If there are trade secrets in that plant, then yes, we need access to those trade secrets.
So what is the scope? I'll ask you the same question. What is the scope of the inspection that you're seeking? Because it seems like plaintiffs were limiting themselves voluntarily. It sounds like you're going in a different direction now.
No, that's actually, Your Honor, Judge Swan. During oral argument at the trial court level, we agreed, as you previously pointed out, to the exact same inspection that the author for Vehicle Pros took, which is mixing through the tire building, through cure, and then quality inspection. And that's what we asked for. And that actually aligns up exactly with our negligent manufacturing claims.
Well, it seems a lot broader than any negligent manufacturing claim could be. What is the claim? What are you claiming was done negligently?
Your Honor, the negligent manufacturing claims were listed in our previous disclosure statements, and that includes a split in the inner liner. That is done in stage 1 of the tire building, so we need to see stage 1. We have poor adhesion and improper age skim stock. That will be seen in mixing. That is how they keep the materials, how they let them age, how they store them. That's directly related to that claim.
So this tire was manufactured in multiple negligent ways?
Yes, actually, over multiple.
Amazing any of them are spinning at all.
Well, that's probably why this tire failed probably within the 6 months of being on this car. And that is an issue that also makes this
Well, I guess if the theory is that each and every stage of manufacture of the tire was negligent, that's something, it would help me to understand that that's your theory. Is that it?
Our theory is that there are specific stages that did cause these defects. And the defects, because we have already pointed them out to Goodyear at Goodyear's request, we have already disclosed the defects that we found on the tire. And we know that those defects are created in different stages through the process.
This is relevant to a negligence claim, not a strict liability claim. So the fact that you pointed out defects doesn't really answer the question. Where are you claiming the negligence occurred?
The negligence occurred, again, in stage 1, there was allowed to be a split in the inner liner in those machines. How somebody did not detect that, what the inspection process is before that goes to stage 2, is the direct type of conduct that we are looking for. You are correct that it's a negligence
So
claim.
what would you hope to see then at the plant?
We want to see how long those tire builders have to make the machine, or to make the tire on that machine. How long does the tire builder have to inspect it before passing it off to the number 2? Does the number 2 machine and builder then actually inspect it before starting his construction? Those are the exact type of things that we can't discover any other way.
Okay. So that's one thing you want to discover.
Correct.
Understood. What else?
Then, most important to a lot of this is the quality insurance. How were these defects not detected before this tire was shipped out the door? How long does the final inspector have at that tire? What does the actual inspection incur?
Look, everything you're talking about then relates to the human element, not to watching them mix rubber to see exactly how the rubber is composed or cured or any of that. Everything you've mentioned relates to inspection, alertness, time. Am I hearing you right?
Some of it, but it also involves the actual processes at the plant. The calendaring involves how long these materials are allowed to be out before they are aged. And the exact calendaring lets us know that if is Goodyear actually following its own calendaring, and we can't know that without being there. And obviously the calibration of the...
You think they're going to take you on a tour and show you that, this stuff's been out there for a year, but don't worry about it?
They very well might not, but all we can do is we have made this claim, we have pled this claim, and we have a right to discover the information that is necessary to this claim.
Why couldn't you do it through depositions? Why couldn't you take the deposition of, let's say, the supervisor who would come in and say, this is how we mix it. This is how long we cure it. This is how long the inspection, how long, inspections take at each point. Are you saying that, is your argument that that's not good enough because unless you actually see it occur, you don't know if they follow their own guidelines?
That's one of the reasons, Your Honor, but also we shouldn't have to take Goodyear's word for it for what it does. That puts Goodyear on a different playing field as it puts us.
This is a 2-hour tour?
Yes.
So you expect to see the whole process of a tire being made in 2 hours?
We expect to see the process that's most relevant to our claims. And as Your Honor pointed out earlier, we're willing to work with them and narrow it to the ones that are most relevant to our defect claims.
Well, again, it sounds like the human element is the most relevant to your defect claims. I mean, it would seem, I don't want to put words in your mouth, but it would seem that if your argument is this tire is so fundamentally negligently made that anybody driving on them shouldn't expect to get home tonight, that probably isn't a claim that's going to succeed. Your better claim is, as you've articulated, which is, boy, these inspectors only have 3 seconds a tire. No wonder they missed the problem in this one tire.
That is a large part of it, but the actual machines are also a large part of it. You heard counsel come up here and say these machines are so incredibly unique that nobody knows anything about them. How are we supposed to know how this tire is made if there's absolutely no other way for us to discover it other than seeing it?
Well, if your expert is an expert in tire manufacture, this can't be a total mystery to him. I mean, how many ways are there to make a tire? This isn't super tire. Right? This isn't the tire that everybody wants if they can save up enough money. It's a tire. So at some level, the exact inspection of the machine seems extraneous to your negligence claim.
Except for, Your Honor, Goodyear has claimed that their tire machines, like I said, are so unique and so different. And as you know, Mr. Carlson has been under a protective order in every single case he's ever been in. So it would be absolutely inappropriate for him to come in and say, this is what I learned from this prior case, and this is what I think went wrong in this case based on what I learned from those machines.
But counsel, Mr. Robertson suggests that Mr. Carlson is not the most reliable individual who apparently, in his view, regularly flaunts and ignores these protective orders.
And Your Honor, I would ask you to review again the appendix that actually cites these orders that Mr. Carlson has violated. The most recent one, and there has only been one, is from the 90s, and never once has Mr. Carlson ever disclosed documents or trade secrets in any of these cases. And to say the speculative harm, to say that Mr. Carlson, under contempt of court, is going to go and disclose these trade secrets when we know that Goodyear 20 years later is still going to bringing this up in every single hearing, is not the type of speculative harm that prevents us from discovering necessary information. This information is necessary to our negligence claim.
Are you saying there's something, or there may be something about these machines that you have to see it in operation? That your expert has to see it in operation?
Absolutely. That is, we want to see how this tire was made. We have claims that there were defects made in each stages of this.
The machines versus what Judge Swan has kept referring to, and appropriately so, the human error. You're looking to say are you arguing that there might be something unique about these machines that contributed to negligence?
That very well could be, because when the tire is actually being made is when some of the inspection is occurring. It's actually as the belts are being wrapped is when the tire builder is doing the inspection. So there's no way to differentiate those two things.
Well, what does the machine have to do with the inspection? I mean, it seems fairly clear that these tires are made, that they work often, right? So it is not as though somebody made a mistake and used a square machine to shape the tire. The question is whether they're being used properly, or whether they were being used properly in the case of the manufacturer of this one tire, correct?
In terms of our strict liability claim, this one tire is what we're looking at. But the function of the machine, the way it wraps the belts, that is how the tire is actually made. It is not a person.
That's fascinating, and probably is fascinating for a lot of reasons that make Goodyear very nervous. But why is it relevant to your negligence claim?
It's relevant because that's how the defects ended up in the tire. And we have to prove that the conduct of Goodyear in making that tire was negligent. We have no other way to do that other than actually inspecting the way in which Goodyear makes tires.
How close are you going to get to a machine on a plant tour?
I'm sorry?
How close are you going to get to a machine on a plant tour such that you can evaluate its design and function and the software that controls it and all that? I mean, it doesn't seem that you're going to be able in such a tour to discover information from the machinery or from the chemical labs that is going to be as relevant to your claim as the human element that could lead to a defect in a single tire.
And, Your Honor, both of those pieces of evidence could be very important, but the point is we get to discover both. We should not have to be limited to just discovering one type of evidence. How that machine works, and even just watching one full tire go through it, if this machine is so unique, we need to be able to discover that evidence.
Are you saying that by observing the tire, the machinery and process, the assembly of a tire, that it might lead is reasonably calculated to lead to other admissible evidence?
Absolutely, and it's not only just discoverable, it is our only option for discovering this type of information. We've asked for the manuals for how this tire was built. We didn't get them. We've gotten the name of one tire builder. Goodyear itself has said that there's no other way to get this information.
Well, the manuals are probably more trade secret than the tour itself.
Well, and Your Honor, that's actually an interesting point. When we were talking about Mr. No's affidavit, there's actually no mention as to what type of machine our tire was made on. It said that some of the machines they modify or some of the machines are proprietary. We actually know nothing about our machine. And, that leads to the burden of the trade secret issue.
It's like a good topic for a meet and confer.
Exactly. And we made every effort to meet and confer, and we were met with resistance. I'm sorry. I was looking at the wrong time. And, Your Honor, I just want to wrap this back to where we are. This is an abuse of discretion standard. The trial judge had all of these facts in front of him, and he balanced the interest that was directly in line with Arizona law. Arizona law is, Judge, I see that you have a question pending on your.
No, I was just listening.
Arizona law requires that a court look at what's in front of them, look at the facts, and narrowly issue an order based on those facts, and that's exactly what happened here. Nothing about this order supports an abuse of discretion.
Well, again, as I've commented, this order is still nascent. It's not yet clear exactly what's subject to discussion. But you wouldn't argue for, the classic example, of course, of a trade secret is the formula to Coca-Cola. If you drink a Coke and you get sick, you're not going to argue that you get the formula, are you?
I've never done
because that's happened. I think people have gotten sick.
I've never done a Coca-Cola case. I can't say with that, but we're not asking to go in and dip into their skim stock and take it away and analyze the formula. We have a claim that this tire was made negligently, and what could be more relevant than how it was made?
Was made negligently, right? You don't have a claim that all of the tires in this class are negligently made and should be immediately recalled from the market.
That is not something that's pled for us, but we did.
But then let's follow that. Let's follow that logically. If you're not saying that the composition of the rubber is so negligently designed that not one of these tires should ever be sold again and they should all be taken and disposed of. If your claim is that this one tire was negligently made and that Goodyear should be held liable for that negligence, then doesn't that change the scope of what you need to learn? You don't really need to know what the formula is for the rubber or the various types of rubber, right?
And we haven't asked, that's not what we're asking for.
Well, then
Correct.
Why do you need to be in the lab?
Because we don't need to be in the lab. The mix, I think there's a confusion as to what the mixing means. What we just want to see is where they start the process, and that's where it shows what is put in and how aged it's going to be. If it turns out that there's something that's so intensely...
It aged for longer than 2 hours? Because my guess is it is.
Well, there's actual calendaring on all of these, on all of this rubber and all of the chemicals and everything that's put in that lets you know if they're using aged product. But again, that's something that if that is their most secret area in the entire plant, we were always willing to work with them on that. What's most important to us, and exactly what I said to the trial court, is the tire building machines and the inspection process is what we most want to see. And that's what's most relevant to our claims.
Okay. Thank you. I think that helps.
Okay. And Your Honors, I want to just briefly touch on in my final minutes that this is a relatively unique case, and the fact that this tire failed so quickly after it was put out there, and this tire is still being made at this Buffalo plant, and as far as we know, nothing has changed. One unique difference...
As far as you know, how many others have failed?
There's our companion tire, which was also presented to the trial court. We argued this. The companion tire was a tire that was made the exact same week as our tire, and it was on our same vehicle, and that tire had the same defects in it as our tire.
Do you know of any other tires? Has there been, let me change that. Has there been any discovery about other tires failing in that quickly a time period from this plant?
Yes, Your Honor, and I don't want to get into the discovery disputes that are currently going on, but we have asked for all of that information from Goodyear, and Goodyear has restricted us to only 6 months after the date of our crash. So we don't know yet the full scope of what's out there.
Of other possible failures of similarly made tires.
Exactly. We are still seeking that information. But interestingly, Goodyear told us, and I want to read this exactly because this is a quote. This is information that Goodyear told us we were required to disclose in order to properly pursue our claim. Goodyear insisted that plaintiffs identify the process plaintiffs allege is defective and that plaintiffs provide a description of how any manufacturing event allegedly rendered this unreasonably dangerous. Goodyear has asked us to tell them what event in the manufacturing process caused this tire to fail. How are we supposed to do that without at least seeing that process?
If you know the component that failed, and you're arguing that there's a prospect that the inspection was inadequate, that enables you to give some sort of answer, right? To simply say, we've got to know everything about this tire to answer that question is not really an answer that's worthy of the information you already have. You know where the problem is.
We know where the problem is, and that's for strict liability, but we have to prove where and how the conduct caused these defects. We have a right to discover that information. We have a right to be put on an equal playing field as Goodyear, and justice requires that we get the same information that they already have. There is no other access for us to gain this information, as Goodyear itself has admitted.
A right to discover that information. What is the source of that right?
That right is that our claim is a negligent manufacturing claim.
Generally, discovery is considered a matter of legislative grace. It's not a right, as it were. There is discovery contemplated by the rules, and there's judicial discretion over the scope of that discovery.
But if I understand your argument, though, is that the right that you're talking about is a right within the rules.
Correct.
And that you're saying, if I understood you, you're saying that Judge Warner followed those rules in allowing the discovery to take place. So you're not saying you have an unlimited right to all this information.
That is exactly correct. We have a right to request it. It is obviously relevant to our claim. It is actually central to our claim. It's not just this broad outreach, hey, we want to walk around the plant and just see what's going on. We have a very specific set of manufacturing processes that we wanted to see. And the judge considered both sides, and he made a ruling that is directly in line with what he was supposed to do.
As Judge Schwan appropriately pointed out, I mean, if there are disputes, it could be brought back to Judge Warner and say, meet and confer. If there's a dispute, work this out.
And that is exactly what we are instructed to do, and that's actually what we tried to do, and we were shut down by Goodyear, and now we're here. And there's just nothing about that order that is an abuse of discretion to allow the extraordinary relief that they were requesting. This is a discovery dispute. In every single product liability case, there are trade secrets implicated. Every single one. There is a protective order in every single case. And there is no difference from Goodyear showing its highly confidential documents to Mr. Carlson than it is for us to walk through the plant and see the same things. It happens every day. And nothing about that order contradicted anything in Arizona law. And just to make a final point, in the decades of product liability suits that Goodyear has had, and the probably thousands of cases, never once has there ever been a disclosure of trade secrets. Not once. And they've, as we all know, had Mr. Carlson against them at least 100 times. So that type of speculative harm argument cannot defeat our right to discovery in this case, discovery that has already been found to be relevant by the trial court.
But again, that's a dispute, an area of dispute that could be raised to Judge Warner. Right?
Exactly, and that is exactly what we argued in our petition, that this is a premature hearing. We don't even know yet what the judge is going to decide about the specific areas of the plant that we're going to be allowed into, because he instructed us to meet with him. And, Your Honor, I see that that I'm out of time. But
well, thank you both for your arguments today. Very helpful. The matter is now under advisement, and we will issue a written ruling in due course. We stand adjourned.